Again, my name is Richard Costa. I have been 10 years in the hacker community and decided to finally go to law school and put my talents to even better use and kind of take the best of both worlds there. So today we're talking about electronic discovery. And my first legal disclaimer, you can read that. I'm not sure if these are actually effective or not, but nothing here is actually legal advice. And I haven't passed the bar yet, so I just graduated. So don't listen to anything here that don't do anything. Talk to a real lawyer. Okay. So electronic discovery, why this matters. Electronic evidence is everywhere. And I'm not going to read off the slides because you guys all have the slides on your CDs. And just so you know, the CD I put together, the slides, it's very detail oriented. You can pull up the information there yourself, especially if you don't have time to stay for the talk. I wanted to produce a resource for you guys to have the cases, to look up the cases on Google and to read the facts of the cases and apply it to your own situation, because you do not have to be a lawyer to understand legal cases. Just Google it with a citation on the slides, and I'll explain some of them here. But the main thing is that I want to breeze through some of this and actually get to some of the Facebook stuff, which I think a lot of people are the most interested in. But mainly with electronic evidence, that's something that the court can order you to compel you to produce, rather. And everything these days is electronic. So we're not just talking about email servers and access logs for routers. We're talking about if you put something on your Facebook, that's electronic stored evidence, and that is subject to a court order depending on the circumstances, and we'll get to that. So, the thing is that a lot of times, especially in a larger corporation, you have servers, incremental backups. It can be a very costly endeavor for something as simple as a sexual harassment lawsuit to pull up a bunch of emails between two coworkers. And the thing is, court don't care. Very expensive, deal with it. You might want to take that into account in your corporate or state policies regarding how you back up your software or back up your data, because the court will order you to produce this even if it's very, very expensive. Excuse me, I'm fighting a cold here. The other thing, aside from producing the evidence, is the deletion of data. And this is something that courts do not look very kindly regarding. And so I put a couple cases here. And, can you delete data or can you not? Well, the answer is it depends. And so these are all very recent cases. These are not cases that you would find, let's say, in a law library, because there's too recent, 2009. And yes, you can have aggressive data deletion policies, but they have to be well enforced, and the whole idea behind them is to not skirt around the law. So if you guys remember the whole Enron scandal with Arthur Andersen, they really tried to skirt around the law. They tried to stay within the lines, but it was very clear to the court that they were actually trying to get around keeping the data. And so having these policies and enforcing them is what allows you and your company to not get sued or to not be penalized by a court for failing to produce data, because obviously you can't be expected to store the data forever. However, you just can't have, if you have inadequate data retention policies, the courts will ding you on that as well, and I put the case there as well, but we'll move on. The other thing is we have, when it comes to electronically stored information, is the failure to preserve the evidence, not even through necessarily deliberate data deletion, but through negligence or actually contaminating the evidence, and the sanctions for that can be very, very severe. In this first case here, I think, the plaintiffs actually won, but they had to pay more money than they won because they did not produce the evidence the court ordered. So if you don't produce the evidence, you piss off the judge. One of the worst things you can get, people try to be sneaky. They think, this evidence is so damning, they will just delete it and they'll deal with the consequences. And the thing is, maybe these judges are in their 60s or their 70s. They don't use Facebook. Maybe they don't even use a computer. But you'd be amazed at how smart these judges actually are. And dealing with lawyers day in and day out, they know when someone's trying to pull a fast one. And if you try to delete something, and they will basically assume the worst. So you will often get, if you do something like that, what's called an adverse inference, and they will tell the jury that the jury can basically assume the worst of the missing evidence. And so tread very carefully when it comes to thinking, I'll just delete this email because this is a hot potato here. And again, the judges don't like much excuses, and the whole dog ate my homework never really flies here. And in these two cases here, again, these are just both examples of, as you can read on the slide, both examples of some of the severe penalties that courts have done when it came to some of that evidence that was not produced. We'll have time for questions at the end, or you can talk to me afterwards. We don't have a lot of time here, but I would definitely love to talk to you after the talk. Again, this is a great case for the whole missing file inference. I think not even just lawyers, but a lot of IT people think they could be sneaky, delete the file, but when it comes to forensic experts, they can see when a file's been deleted. It doesn't take a total genius to figure that out. And as I said, judges don't take too kindly to that. Let's skip past here. Here we go. This is a great couple cases here. We all have to talk about metadata. And when it comes to evidence, one of the things that the other side, who's requesting the evidence in a court case, they have the right to actually analyze it. So let's say, though, you have, let's say you have a WAV file and a voicemail, and you give it to the other side in an MP3, a lossy format. Well, now their forensic experts can't take that sound file apart bit for bit to see if it's been altered. And or when it comes to, let's say, having a Word document and converting it into a PDF, you lose a lot of the metadata, the serial number for that copy of Word that's embedded, all those things that a lot of programs try to filter out to scrub the metadata. And that's something that courts are very well aware of. And so you have to be very careful when it comes even to unintentionally changing the data format, because, again, it's not just what the document says that's important, the email, it's what's hidden in it that is also evidence, that is also something that you're ordered to produce, and that judges will assume the worst if you don't provide that to the other party in a litigation. Sorry about that, Colt. Okay, well, let's jump to the Facebook stuff, because I'm not sure how much time we have left, Jason. So one of the things is that the law always takes time to catch up with technological developments, and of course we've had this explosion of MySpace, Twitter, well, not MySpace, but Twitter, social media, etc. And a lot of companies, for example, corporations have a Twitter feed, or they have a Facebook, a corporate Facebook page that multiple people maintain or whatever, and that is actually electronically stored information. And just how a company needs to keep all their accounting files and all their emails, and for tax purposes, for lawsuit purposes, etc. Facebook information does now count as that, is electronically stored information, and that is something that they are required to back up. So if you have a company, many of you in the audience, work for a corporation and probably do back up a lot of information there to meet various requirements, whether you're HIPAA in the healthcare industry or Sarbanes-Oxley if you're a publicly traded company. Well, if you're not backing up your Facebook, then you are actually opening up yourself to litigation in a non-legal advice sort of way. And again, penalties, most people don't think of that though. because it is something that's so ubiquitous, and people don't think it's important, but there have been a lot of cases recently where some random person in a company, some disgruntled employee, puts a bunch of nasty information on a Twitter feed, and that goes out instantly, and that does have legal consequences. So that's just one example of, yeah, you do have to control your electronic stored information, but also back it up. Okay, well, the big thing here is privacy. So do privacy settings in Facebook matter or not? Well, let's see. We have this great case here let's see. Sorry, I've been studying for the bar the last couple months, so I haven't had a chance to review these slides. Okay, so yeah, part of the law is about the reasonable expectation of privacy. And unfortunately, as people, the public, have a lower expectation of what is private, the law actually follows that because it follows this whole reasonable person standard, this reasonable expectation. And unfortunately, these companies, in their end user license agreements and things like that, they say to protect themselves, don't expect this to be private, even though there's privacy settings. And so courts, sometimes they go by that, and sometimes they go the other way. So in this other case here, this court held that no, having data flagged as private or account as private does not shield it from an e-discovery request. But this is not the law. This is one case, and there's cases that go the other way. But the thing to know is that there are these cases out there, and you have to distinguish your case from these other cases. So for example, some courts look at the fact that, okay, the default settings are public, and this person, they change their setting to private. So that's kind of an affirmative step on the part of the person to make their profile private, and therefore that information on their profile shouldn't be subject to e-discovery. Well, other courts will look at the end user license agreement and say, sorry, the company says don't expect privacy. So it goes either way, but unfortunately, excuse me, unfortunately the battle for privacy is a rather losing battle, but it's not quite lost yet. But so we have another great case here. Oh, this is a good one. Yeah, so this court, this federal circuit court in federal district court in California, they said that yeah, these private messages are not subject to subpoenas because they fall under this Stored Communications Act, which was designed actually for email way back in the day. But unfortunately, as we see in this New York State Supreme Court case, oh, thank you. But unfortunately, as we see in this New York State Supreme Court case, they not only allowed retrieval of data that was indicated as private, but they actually forced Facebook to restore the deleted messages and posts. So even the act of deleting wasn't sufficient for this court to view it as something that was not discoverable. Oh, this is a great comic I found here. I'll read it for those who are too far away. So it's a little fake Facebook page. The defendant saying, "I can't believe I'm getting away with murder. I'm guilty of sin. Yada, yada, yada." The plaintiff, the attorney, the DA reads that, and of course he likes that because it's basically a confession. And the judge, of course, finds him guilty based on this electronically stored evidence. And of course, the defendant is not very happy. But it's funny, but this is actually very true and extremely relevant to what goes on today. So, for example, something as simple as someone doing an insurance claim, claiming they're disabled, and they post a picture of themselves skiing. Well, on their Facebook, and let's say and let's say their profile is private. Well, in some jurisdictions, having your profile as private will save you, and in some jurisdictions, it won't. Okay, here's another great case related to that, and let's see. Well, that's again. This is the kind of stuff here that you can look up. That, for example, you just copy the Liddick v. Roman and the information after that. You put that in Google, and you will find the whole text of the case. Because although there's a lot of private companies that charge for full access to the case text, there are plenty of free resources out there, and they'll just pop up in Google, and you can actually read this. And this is, yeah, these 2009 cases, they aren't even in the law books yet, because it takes several years for the books to actually catch up. So Google and the case names are a great resource to actually research what's going on with some of these cases here. But so we had that little fake screenshot here, and let's say this is real. How do you admit this as evidence in a court case? Well, there are, the most basic way would be to do a screen print and hand it to the judge. Okay, well, sometimes that might work, especially in a more rural court, but this one case here, the second one here, Treat v. Tom Kelly, the judge wanted that printout to have a timestamp. That's pretty reasonable. And in other cases, though, they wanted something a bit more. So, for example, judges will actually go onto your Facebook, you friend them in court, and will look at it in real time, because you don't have control over this information. It can't be faked, and that is one of the great ways to get this information admitted into court. The other way, of course, would be to have an expert witness who would document their methods and procedures and get admitted as an expert and qualified as an expert by the judge, and all that costs money and time when you can actually just get friended in court like that. But there's a lot of, I talk to a lot of people, and I've heard this so many times. They're involved in a court case with someone, and they're like, hey, can you friend so-and-so, because my son got in a car accident with him or whatever, and he's claiming to be injured, but I know he's fine. And as a person in the legal profession, it's kind of skeezy, friending someone under false pretenses. But even as someone from the hacker community, I always felt that such tactics were rather skeezy and, well, unchallenging, if anything else. And it's great that just as the law takes time to catch up, in the legal community, the whole self-policing ethics boards themselves take time to catch up. So I just put this great case here, well, not a case, but an opinion from the New York Bar Association that says no, lawyers should not be doing this. This is beneath us. The proper way to deal with a lot of this Facebook evidence is you go the proper route. You talk to a judge, you get an e-discovery request, and you don't, pull these little scammy little tactics. But, well, anyway, I'm sorry I had a bit of a cold here, but I'd be happy for anyone who can't meet me afterwards. Please contact me. I would definitely answer any questions you have in a non-legal sort of way. And yeah, I think we're just about out of time here. So thank you very much. And talk to me afterwards. I'll be around outside the hallway.
Thank you, Richard.